Hey everybody, it's Joel Williams and Chase Elleby at Williams Elleby. Today we want to answer a question we get quite often, and that is, how do I settle an injury claim outside of court? So what's the first thing you need to do, Chase?
Well, the first thing that comes to mind is you want to gather all the evidence that you would need to support your claim in general. And I'll start by saying that most cases do get resolved before you actually get to court. Filing suit, litigating, and things like that are separate than actually going to court. But most of the time, cases get resolved before you actually have to step foot in court. But number one, you got to gather your evidence. That's medical records, statements, photos, whatever it is that you need to prove your case.
Yep. The second thing I would say is get in touch with an attorney. I know I'm an attorney, so it's a little bit of a self-serving statement, but I can tell you without a shadow of a doubt, if you find a good personal injury attorney that insurance companies respect, or at least have a healthy level of fear of, then your chances of getting a good pre-suit settlement offer are going to go up.
Yeah.
So you may send a demand yourself and they go, oh, this person doesn't even have an attorney, and they may offer you $10,000. You may get an attorney that the insurance companies know is willing to take them to the mat, and that offer may all of a sudden go up to $20,000 or $30,000.
Yeah. Good, absolutely. So the third thing is you need to actually calculate your damages, right? What are you going to ask for? What is it that you're seeking compensation for? So your damages are typically going to be your medical bills if you treated, and then you have your intangible damages, which are pain and suffering. That's, sort of the how did this wreck or this incident impact your life. You also have lost wages, you have future lost wages, you have future medical bills. So you need to calculate all of those to get an idea of what the value of the case is, so you can demand that certain amount from, say it's the insurance company or the at-fault party.
Yep. And next week we'll actually come and talk to you a little bit about how medical bills are handled in at least Georgia personal injury cases. But the fourth thing you need to do, and this is actually probably should be closer to the top of the list, but you need to notify all of the important people and parties that are going to be involved in these settlement discussions. So the first people you need to notify is the at-fault insurance company that you're bringing a claim. You should also send a letter to the person who, or the entity that's responsible for your damages. And in that letter, you should ask them to preserve all evidence that may be relevant to your case. If it's a car wreck case, that might be the other car. If it's a slip and fall case, it might be closed circuit video or anything that may be relevant to it. Let them know that they have a duty to preserve it, so that if they destroy it later, then you can use that letter to show the court, hey, I told them I was bringing a claim. They still got rid of evidence that could be needed. Another entity, at least in automobile wreck cases, that you need to notify is your own insurance company. You have to do that within a reasonable time frame. Exactly what that time frame is going to be determined by the language of your automobile insurance contract, but it has to be within the time frame allowed by that contract. Even if you don't think you're going to need to bring a claim, it's best to go ahead and notify them so that they can't come back later and say, well, you didn't tell us about your wreck, so we're not going to provide any uninsured or underinsured motorist benefits to you.
Right. And one more thing, I don't know if you mentioned it or not, is that you want to let your healthcare insurance company know, put them on notice as well, if healthcare is involved, and we'll talk about that next week as well. The next thing you need to do is obviously send the demand, right? Send the insurance company, whoever it is you're dealing with, what you're actually demanding.
With the demand, are you talking about like call them up and say, I demand $10,000, or are you talking about some other way?
Yeah, it's a good point. It could, most of the time you send it in writing, right? And you send it in writing, you give them a certain amount of time to respond to that demand so you can trigger bad faith, right? So it goes back to what Joel said earlier. You want to talk to a lawyer. First and foremost, they'll give you advice on what to do. If you hire them, they'll know how to send the demand, how to trigger potential bad faith, cause of action, and things like that. But you send the demand. Once the demand is sent, you try to negotiate that. If you can negotiate it without having to mediate or go to trial, that's great. But a lot of times cases do end up mediating. And mediating, I know we've had videos on that before, is basically where both parties have a neutral, which is usually a retired judge or a lawyer who's worked both sides of cases, and bring the parties together. One side gives their take on the case, the other side gives their take on the case, and the sides just go back and forth to try to get the case resolved. The good thing about mediation is that you're not in front of a jury. it's formal yet informal in the sense that there's not, you're not in court or anything like that. And you as the plaintiff have control in determining whether or not you want to resolve the case. So there's a huge value to mediation. Most of our cases are mediated at some point. Most judges will order cases to mediate before you can even go to trial because of the success of mediation. So.
Yeah. And another point about mediation is there's a couple of benefits to it. They don't happen a lot prior to a lawsuit being filed, but they can happen. If both sides recognize that they have risk, and especially if the person who caused your injuries understands they have significant exposure, that they may have to pay you a lot of money, then mediation is sometimes an attractive alternative rather than just going back and forth with numbers, because a mediator can give you insight into your potential upside as well as your risk if you were to file a lawsuit and if you were to go further. So sometimes if there's an impasse in negotiations, if you can get a mediator involved, then that'll get you across the finish line and you can get the case done.
Yeah.
The final step with trying to get cases settled outside of court is to finalize an agreement if one is reached. And that's usually done through a formal settlement agreement, or what we call a release. Now, this is a part of the pre-suit negotiation process and getting a case done, where if you don't have an attorney, you can sometimes get yourself in a pickle.
Yeah.
So different states have different laws on what type of releases are required. Now, every insurance company is going to have a form that's going to be absolutely favorable to them and not favorable to you. So if you're going to settle a case pre-suit and you're not going to have a lawyer, it's going to be very important to educate yourself on the language of the statute in your state that applies to the type of release you can enter into. And the perfect example would be in a car wreck case in the state of Georgia, you can enter into what we call a limited liability release, and that allows you to accept the full amount of the insurance money available from the person who caused the wreck, but it also preserves your ability to pursue your own underinsured motorist coverage if the person that caused the wreck doesn't have enough insurance to cover your damages. But if you don't sign the correct type of release, you'll be completely barred from doing that, and that could cost you tens of thousands or hundreds of thousands of dollars. Yep. So we don't just say, talk to an attorney because we are attorneys and that's how we make our living. But we hate to see insurance companies hold on to all this money when they're taking advantage of a small loophole, if you will, that most people don't know about.
That's right. Insurance companies are going to be incentivized to people who are pro se, meaning don't have lawyers. They're always going to send, in Joel's example, in a car wreck example, they're always going to send what's called a general release, because the general release protects their insured more so than a limited liability release. So if an insurance company is saying, hey, Johnny, I'm going to pay you that $25,000, that's all the coverage we have, you just need to sign this release, you have to be extremely careful as to what release you're actually signing, because you could, like Joel said, literally sign away hundreds of thousands of dollars in potential recovery, because by signing a general release, you can no longer go after your own insurance company for any uninsured motorist coverage, which you've likely paid for years and years and years and years and didn't even know you had it. And then you sign the wrong piece of paper and you can't even access it.
Yep. And you have to be careful about who has to be paid back out of the money you get. So
right.
Some releases will have language in there that would require you to pay back bills that you don't actually have to pay back, like
right.
health insurance liens, if it's the right kind of policy and all of that kind of stuff. So there's a lot of little things that you have to be very careful about. But I guess the overall main point is, number one, please, please, please get an attorney in whatever state you're in. Number two, you have to be thorough in gathering all of the evidence that you can need to prove that the incident was not your fault, that it was somebody else's fault, and specifically that it was the fault of the person who you're asking to pay you money, or their insurance company to pay you money. Then you got to gather the evidence, like your medical records and bills, to show that that incident caused the injuries you're saying they caused, and to prove the extent of your damages. And if you have lost wages and things like that, you need to get your pay stubs, you need to get your hourly wages and how many hours or how much money you typically make on a weekly or monthly basis.
Right. It could be 1099s, could be tax returns, things like that.
So you got to gather all that stuff together, and it can be a lot of work. And I know people a lot of times complain about, well, lawyers get paid too much money or whatever. Well, yeah, we do get paid a decent amount of money sometimes, but there's a reason for it, and it's because of all of the education and experience we have to get to the point that we're able to explain things like this to people, and then the legwork and the effort that we have to put in to gather all this stuff. So you can certainly do it on your own if you want to. You just have to be very careful, or you can hire an attorney and let them do it for you to make sure it's done the right way. So,
yeah, I think that's it.
Any other tips on how to settle cases outside of court?
No, not that we haven't already talked about.
All right, good deal. Well, we hope this video has been helpful to you. If so, give us a thumbs up, hit that subscribe button. Otherwise, we will see you next week, where we'll be talking about how to handle medical bills and medical records in personal injury cases.